La séance est ouverte. Bonjour.
We'll now call the meeting to order. Good afternoon, everyone. I would like to welcome all of our witnesses. Pursuant to its order of reference of Wednesday, February 13, 2008, the committee is resuming its study of Bill C20. Today, it is our good fortune to have three professors as witnesses.
Upper Canada, Kingston, Ontario. We have Ronald Watts, Professor Emeritus at Queen's and a former director of the Institute for Intergovernmental Relations, and also president of the International Association of Centers for Federal Studies. As we all know, our federal system needs a lot of study these days, so welcome. And we also have Richard Simeon by way of video. Mr. Simeon was also a professor of political studies at Queen's and was director of both the School of Public Administration and the Institute of Intergovernmental Relations. Among his many national and international achievements included his publications Small Worlds, Provinces and Parties in Canadian Political Life. We always say it's a small world here on the Hill, so we'll be fortunate to welcome Professor Simeon. And we have with us also Andrew Hurd, the author of many publications, including The Marriage of Law and Politics, and of course around here lately, the two have been on trial separation, so welcome. So without further ado, we'll begin with Mr. Watts.
Madam Chair, let me express my appreciation for this opportunity for this invitation to present my views on Bill C20. I wish to draw attention to two concerns about Bill C20 in its present form. The first has to do with the legislative procedure, and the second with the lack of context in terms of the relation of the selection process to the character, functions, and role of the Senate within Parliament. Turning to the first concern relates to the use of ordinary legislation to effect what is in substance a constitutional amendment. The explicit objective outlined in the preamble to Bill C20 appears to be to replace patronage in the appointment of senators by a more democratic electoral element in the process of selection. Bill C20 indeed appears to have been very carefully crafted to create a procedure which neither contradicts nor purports legally to alter in any way the Governor-General's power of appointment or the Prime Minister's right of advising the Governor-General. But it violates the spirit of the Constitution Act 1982, which explicitly states in Section 42(1), and I quote, "An amendment to the Constitution of Canada in relation to the following matters may be made only in accordance with Section 38(1), and lists in Section 42(1)(b) specifically, and again I quote, the powers of the Senate and the method of appointing senators. Section 38(1) requires not only a resolution of the Senate and House of Commons, but resolutions in 2/3 of the provinces that have an aggregate in at least 50% of the population of all provinces for such amendments. The purpose of this amendment procedure, outlined in Section 38(1), is to ensure a broad consensus for amendments to the basic features of our constitutional structure. Difficult as this may make amendments, nevertheless, this requirement is fundamental to Canadian federal democracy. The effort to avoid this procedure by reforming the Senate on the sly through the devious use of ordinary legislation constitutes, in my view, an anti-constitutional process. It purports to seek a democratic objective by resorting to a non-constitutional and hence ultimately anti-democratic process. The Supreme Court in 1978 declared that, and I quote, "to make the Senate wholly or partially elected body would affect a fundamental feature of that body. And the Supreme Court went on to say and to give clear and unanimous guidance that Parliament could not unilaterally alter the, and I quote, the fundamental features or essential characteristics of the Senate. No matter how democratic the objectives of Bill C-20 may be, and no matter how difficult the process of constitutional amendment may be, those objectives should be pursued by the appropriate constitutional process rather than in the devious manner proposed by Bill C-20. A second concern arises from the proposal in Bill C-20 to alter the appointment process for senators without relating these alterations to the broader context of the role, representative basis, functions, and powers of the Senate as part of the parliamentary structure. Any reform of the Senate must take account of three factors that are in fact interrelated: the representation of the regions and provinces, the mode of possible election, and the powers of the second chamber. To consider just one of these aspects without its relation to the others by a piece of discrete legislation is likely to create unintended consequences in the relationship between the Senate and the House of Commons. For instance, if the current powers of the Senate, equal to those of the House of Commons, except for the introduction of money bills, remain for a Senate whose members gain the legitimacy of an electoral base, this could produce a serious challenge to the principle of House of Commons primacy and of cabinets responsible to it. It is no accident that in virtually all federations elsewhere with parliamentary institutions, even in those parliamentary federations with relatively strong second chambers, such as Australia and Germany, the constitutional powers of the second chamber have been more limited. It is only in federations with separated executives and legislatures, not parliamentary ones, such as in presidential congressional systems, that equally powerful second chambers have proved sustainable. Furthermore, of the 7 federations in which all the members of the second chamber are directly elected, only Australia is parliamentary in form. Other parliamentary federations elsewhere, other than Canada, some 8 of them, most rely on election by state legislators or appointment by state governments or by a mixture of processes. In Canada, despite the almost equal formal constitutional powers of the Senate, in practice, its lack of electoral legitimacy has induced senators generally to play a secondary role on most occasions because of the democratic legitimacy accruing to the House of Commons. That raises the question, would a Senate composed of ambitious politicians with what becomes an electoral base, and with their individual importance enhanced by a smaller chamber than the House of Commons, willingly eschew exercising their full constitutional powers? There's a very real risk that senators with an electoral mandate, even if provided indirectly by legislation, but without modification of the current formal powers, would exercise those powers that they have not dared to exercise in defiance of the House of Commons when they were clearly unelected. Here we might note our pre-Confederation history in the United Canadas. In 1856, with John A. Macdonald's support, an elected second chamber was adopted. But after 8 years of its assertiveness, complicating the operation of responsible government, Macdonald admitted publicly that the elective system, and I quote, did not fully succeed in Canada as we expected. Consequently, in 1864, it was he who introduced into the Conference at Quebec the resolution for appointed members of the Senate. Does this mean that I support the status quo and am opposed to the reform of the Senate? Not at all. First of all, my own comparative study of some 25 federations throughout the world has convinced me of the importance of an effective federal second chamber towards making a federation effective, including parliamentary federations. To those in Canada who would argue for abolition of the Senate, I would point out that of 25 federations in the world, only 5 do not have federal second chambers, and these are the United Arab Emirates, Venezuela, and 3 small island federations, each with less than 1 million in total population, of Comoros, Micronesia, and St. Kitts and Nevis. Virtually all the other federations, although in varied forms, have found a federal second chamber desirable and necessary for at least 2 functions: legislative review and the inclusion of distinctively regional views in the federal decision-making process. For information on this federal experience elsewhere, I am leaving for the committee with the clerk copies of a recent paper of mine entitled Federal Second Chambers Compared, which will lay out in much more detail the experience of other federations in relation to second chambers. As far as the function of independent legislative review and related activities, such as investigative reports, are concerned, the Canadian Senate has in fact, as pointed out in many of the contributions to the book edited by Serge Royal entitled Protecting Canadian Democracy, provided a very useful complement to the House of Commons. Indeed, individual senators, such as, to name a few, Hugh Segal, Lowell Murray, Michael Kirby, have made a superb contribution to the work of Parliament. But as to the second major function of second chambers in federations generally, that is providing a channel for the involvement of distinctly regional viewpoints in policy making within institutions at the federal level, the Canadian Senate's lack of political legitimacy has meant that by comparison with other federations, it has fallen short of the functions performed by second chambers in most federations. These are the functions that Canadian political scientists have come to refer as intrastate federalism. That these functions are important was recognized by the Canadian Supreme Court when it declared in 1978 that, and I quote, "The Senate has a vital role as an institution forming part of the federal system." And it went on to say, "Thus the body which has been created as a means of protecting sectional and provincial interests was made a participant of the legislative process." Given the current weakness of the Senate in performing this federal role, Senate reform is, in my view, in fact, important and urgent. Here I would draw attention to the paper by Tom Kent entitled Senate Reform as a Risk to Take Urgently in the Special Working Paper Series on Senate Reform 2007-8 of the Institute of Intergovernmental Relations at Queen's University. Reform is needed to make more effective the federal coherence of Canada. As one of the most decentralized federations in the world, we need not only provincial autonomy, but federal institutions which bring provincial views more inclusively into federal decision-making rather than depending solely on the processes of executive federalism. Reform to achieve this may require elections to the Senate by a different electoral process than that of the House of Commons, but also a more rational basis of representing regional and provincial interests, and an adjustment of the Senate's constitutional powers to avoid deadlocks, possibly, one possibility, along the lines proposed in the Charlottetown Agreement. This is not the place to go into that prescriptive detail, but reform requires looking not only at the method of selecting senators, but relating this to the role, functions, and powers of the Senate within Parliament. While such full reform is urgent for the welfare of Canada as a federation, it will require constitutional amendment, difficult as that may be, to redefine not only the method of electing senators, but also the basis of representation and powers of the Senate. Piecemeal reform by stealth, unrelated to the broader functions of the Senate, such as proposed by Bill C-20, not only does not go far enough, but is even risky and dangerous insofar as it does not take into account its likely effect upon the relative role and powers of the Senate. Thank you.
Thank you, Mr. Waltz. Mr. Hurd, you have the floor.
Merci, Madame la Présidente. Tout d'abord, je voudrais...
Thank you, Madam Chair. First of all, I would like to thank you for inviting me. It's a pleasure and an honor for me to be here today.
A novel attempt at Senate reform that deserves substantial attention. But unfortunately, unlike many bills before Parliament, serious questions arise about whether this piece of legislation is within the legislative powers of Parliament. And on balance, I am persuaded by the arguments that C-20 is unconstitutional. It can be readily agreed that Bill C-20 does not alter any provision of the Constitution. C-20 directly conflicts, however, with the Constitution Act 1867 in specific details relating to the qualification of senators. These conflicts relate to citizenship, residency, and financial assets. While these conflicts are substantive, they could and should be easily corrected. On the broader details of the election of nominees, however, there are no substantial conflicts with the wording of relevant constitutional provisions. However, the constitutional validity of legislation hinges on much more than the absence of manifest conflicts between the wording of an act and that of the Constitution. Fatal conflicts can also involve a clash with judicial interpretations of the substantive content of constitutional provisions. Potential problems for Bill C-20 arise principally from the Supreme Court of Canada's opinion in the Upper House reference. And the Court held unanimously that Parliament could not alter any, quote, essential characteristics, unquote, of the Senate, and neither could Parliament legislate direct elections for the Senate. When the Supreme Court examined the issues in the Upper House reference, the relevant powers of Parliament were then found in Section 91(1) of the Constitution Act 1867. This section declared that Parliament could amend the Constitution of Canada with 5 exceptions. Read literally, Section 91(1) appeared at the time to have granted power to Parliament to alter or abolish the Senate, because the Senate is not mentioned in the 5 exceptions to Parliament's unilateral powers. Nevertheless, the Court ruled that the essential characteristics of the Senate were beyond the powers of Parliament. Several legal authorities have argued that the repeal of Section 91(1) and its replacement by Section 44 of the Constitution Act 1982 have rendered the Upper House reference moot. It is not clear, however, why this should be so. The essential characteristics referred to by the Court that required protection were not mentioned in Section 91(1). Indeed, they were read into or drawn from the preamble to the Constitution Act 1867. These characteristics have not changed by the enactment of the Constitution Act 1982. Furthermore, the limitations on Parliament's powers to legislate on the Senate were read into Section 91(1) by the Court when no such restrictions were present. The new unilateral amending powers of Parliament found in Section 44 now contain several explicit prohibitions against Parliament acting unilaterally to pass amendments relating to the Senate, including the method of selecting senators, mentioned in 42(1)(b). So rather than consigning the Upper House reference to the dustbin, the constitutional changes in 1982 appear to actually reinforce that decision. Now, the ultimate question that must be resolved is whether the indirect nature of the, quote, popular consultation, unquote, process that does in fact save C-20. Clearly, legislation to institute direct elections would run afoul of the Upper House reference and Section 92(1)(b) of the Constitution Act 1982. So the answer to this question hinges on how literal an approach one takes to constitutional jurisprudence. Some argue that Bill C-20 is constitutional because of the absence of a direct conflict with the legal powers and discretions of the Governor-General in Sections 24 and 32 of the Constitution Act 1867. However, there is considerable evidence that the Supreme Court of Canada would not take such a literal black-letter approach. The history of Bill C-20 and its predecessor C-43 clearly shows that the pith and substance of the bill is to achieve an elected Senate. When trying to establish the true nature of legislation, the courts often ask what deficiency the legislature is trying to remedy. In the case of Bill C-20, numerous government statements plainly declare that the problem they wish to address is the unelected nature of the Senate. It is the government's intention that only those individuals chosen by the electorate will take seats in the Senate. In essence, the remedy provided by C-20 could not be any different if direct elections were instituted. Bill C-20 does contain legal discretion on two key matters that supporters of the measure say are crucial to its constitutionality. There is no obligation, no legal obligation on a government to hold an election for Senate nominees. And there is no legal obligation to appoint any nominee once they have been declared winners. And one can point to the history of senatorial elections in Alberta for evidence that future governments might exercise a discretion to not recommend that the Governor-General select elected nominees for the Senate. Jean Chrétien and Paul Martin ignored the winners of Alberta's senatorial elections for 8 Senate appointments from Alberta between 1996 and 2005. However, Prime Ministers may well not be able to ignore C-20 once enacted. First of all, it makes a tremendous difference that this election process would be enacted by the Parliament of Canada and not by a provincial legislature venturing out of its legislative domain. Secondly, a question arises as to how the courts would react to a suit brought by a nominee elected under the C-20 process who was overlooked for a Senate appointment. Clearly, in my view, the courts would not issue a writ of mandamus requiring the Governor-General to appoint the nominee. There simply is no legal obligation under Bill C-20 to enforce. However, there is every likelihood that the courts would not leave the matter there. In the Quebec secession reference, the Supreme Court could have simply stated that Quebec does not have the right to secession under either Canadian or international law. Instead, the court went on to declare that the Government of Canada would have a moral obligation to negotiate separation if a clear majority of Quebec voters had agreed in a clearly worded referendum. In the patriation reference, the Supreme Court also could have simply said that the federal government can, in law, unilaterally request changes to the Constitution that affected provincial powers. But it went on to declare that substantial provincial consent was required by convention. Thus, it is highly probable that the Supreme Court of Canada would also comment on the government's political obligations to respect the people's wishes under the C-20 regime. It would be all but impossible for a government to ignore the clear wishes of the people in a nominee election process conducted with all the seriousness and substance of a regular election for members of the House of Commons. If Bill C-20 were enacted, it would not take long for a constitutional convention to be established that Prime Ministers should only recommend elected nominees for selection to the Senate. The democratic principle would impose a moral and political obligation from the outset. In the end, then, the theoretical discretion left to the Prime Minister and the Governor-General in C-20 may prove quickly to be a mirage. In conclusion, for all intents and purposes, Bill C-20 creates an electoral process to transform the Senate from an appointed body into an elected chamber. Bill C-20 represents an attempt to radically alter the essential characteristics of the Senate as it was created and has operated since 1867. The chosen method for this drastic reformulation is also intended to exclude the provincial governments whose consent would be required if this reform were proposed through a formal amendment. The Senate was a foundational institution in Confederation over which considerable debate was expended in order to create this country. In 1982, the First Ministers agreed that amendments to the powers and methods of selecting senators should only be done through the general amending formula. As such, the Senate is not something for the national parliament to radically reform without the consent of the provinces. Thank you.
Thank you, Mr. Hurd. And we'll now turn to Mr. Simeon through the wonders of modern science. Mr. Simeon.
Thank you very much, Madam Chair. It's certainly a privilege to be able to testify before this committee, and I thank you very much for the opportunity. And I also apologize to you and to my colleagues present that the press of commitments means that I have to talk to you via video. I confess that I am deeply ambivalent about Bill C20 as well and about how to respond to it. I share most of the concerns that have been raised by my colleagues, but I think I do perhaps come down at a slightly different point. There is much to be said in favor of Bill C20, I think. After decades of frustration in our debates about Senate reform, it does break a logjam, opens the possibility of real change without plunging us into yet another round of failed constitutional negotiations. It does bring an element of real democracy into the process of selecting senators, thus potentially making the Senate more representative, responsive, and accountable. It promises a check on the excessive concentration of the power of appointment in the hands of the Prime Minister, a major part of the democratic deficit in Canada, and the fundamental reason for the weakness of the Senate as an effective body representing regional and provincial interests in central institutions. Creates the possibility of a Senate that is perhaps more effectively able to represent provincial voices in the federal parliament. Professor Watts referred to Tom Kent's argument, and I think I agree with him, that the legitimacy of the central government will be enhanced by election, and that will place some sort of potential check on the ability of premiers to have a monopoly of representing the provincial views on national issues. And I think that would make for a healthy federalism. So there are some good things to be said here. But of course, I have some real doubts about C20 as well, and they are partly procedural and partly substantive. First, on procedure. There are several elements here. The two reforms under discussion, consultative elections and a fixed term for senators, are a very limited second best to more fundamental reform. I realize that the scope of the bills is sharply limited by the government's desire to find a way to make changes by Parliament alone rather than through formal constitutional amendment. But the cost of that is that a full review of the Senate, as Professor Watts said, one that would include the roles and powers of the Senate and the allocation of seats across provinces, will not take place. And yet, all of these factors are linked and need to work together. For example, do we want to enhance the power of the Senate, as this bill likely does, without addressing the gross underrepresentation of Western provinces in Senate seats? Secondly, we've not had a full public discussion about Senate reform here. There's been virtually no public involvement in this process, even though over the years many imaginative proposals for different kinds of reform of the Senate have been made. In addition, as has been pointed out, the Senate is a vital element in federalism, and so the lack of intergovernmental consultation here is a problem. A number of provinces, including a unanimous Quebec legislature, have objected to the bill. Several provinces already have or are considering their own legislation to generate potential Senate nominees. Indeed, I think that suggests an interesting alternative avenue we might explore. What if all provinces were to hold elections for nominees, the results of which would be submitted to the Prime Minister? He would retain his constitutional discretion over appointments and could ignore the result if he felt the provincial processes were undemocratic. But it seems to me a way to achieve a lot of what's intended here without raising quite the same constitutional difficulty that this bill does. The federalism perspective casts another light on the issue of the constitutionality of Bill C20. I do defer to those legal experts like Peter Hogg and Patrick Monahan who have told you that the bill is drafted narrowly enough that formal amendment is not necessary. But even though they admit that we could easily find ourselves in a constitutional gray area, especially if the bill is strengthened. But the reason why we require the amendment for major change in the Senate is because the interests of provinces are so deeply engaged. Whether or not this bill is constitutional in the large C sense of that word, it does suggest, as has been pointed out, a new set of rules that could in the long run significantly affect the role and powers of the Senate, and thus would be a change in our operating or conventional constitution with potentially important implications for federalism. So yes, real procedural problem. Next, make some observation on the substance of the bill. Perhaps the most troubling aspect for me is its uncertain character. The government may or may not decide to hold a consultative election. It may or may not decide to appoint those who have won the election. Elections may be held in some provinces, but not in others. It seems to me that if we are to have Senate elections, let's do it. They should take place everywhere, the results should be binding, and so on. It would be a major confusion, I think, for citizens if they were unsure whenever there was a vacancy, whether there would be a vote and what its effects would be. And it also seems odd that we would legislate the complex and detailed rules set out in the legislation and mobilize all the resources of Elections Canada to manage an election whose status and effect is unclear. Second, I raised the question of when senatorial elections would be held. The bill contemplates holding them either at the time of a federal or provincial election. The Chief Electoral Officer has argued persuasively that coordinating with provincial election law could be very complicated, so it's most likely that senatorial elections would coincide with federal elections. But there are problems with that. The likelihood is that the Senate election would be lost or drowned in the broader focus on the general election. Senate election results will be driven by the preoccupations of the national parties. It would be difficult to keep funding and other activities of the Senate and general elections apart. Far better, I believe, would be to conduct Senate elections separately on fixed dates. Perhaps one day every 2 years could be set aside as Senate Election Day, with elections held for all vacant Senate seats on that day. That would make it simpler to administer, reduce partisanship at least somewhat, and would provide provincial electorates with a much greater ability to reflect on how they wish their interests to be represented in Ottawa. I also have a word or two about the single transferable vote system that is provided here. I don't want to say much about that because I'm running out of time. Let me just say that I think if we're going to introduce two major sets of changes, a changed electoral system and a fundamentally changed Senate, then we should realize that there is an enormous public education process that is necessary here. We've had two failed referenda about electoral reform in Ontario and BC, and that's partly because in neither case was there proper provision for educational process. Well, there are a number of other issues here. The funding provisions are unclear. Campaigning will be expensive. It's unclear why political parties can contribute services but not direct funding, why there are no direct limits on direct contributions to candidates as different from other elections, why there should not be some form of public subsidy for senatorial election candidates. And I think these kinds of questions all have a bearing on whether and how much we want Senate elections to be inoculated against a party influence or not, and indeed how seriously we take these elections. So much clarification is necessary. The most important question is, of course, in the very long run, what would be the effects of these changes? Well, political scientists and constitutional designers have a very poor track record of predicting the consequences of institutional change. But clearly, as has been said, this is pretty fundamental. Once the system is in place and accepted, the Senate would have far more legitimacy and hence influence than it has at present. It would be a significant alternative center of power, especially since its powers would remain antique. We might say that, oh, well, the Commons would remain the confidence house with the power to make and unmake governments, but that's a convention, and it could easily change with a more legitimate Senate. But I'm not sure that these doubts and uncertainties about the long-run future should stop us doing something now to get this ball rolling. So let me conclude by saying that I do not love this bill. I see it as an incremental ad hoc effort whose main outlines are indeed shaped by the desire to make some change without falling into the pit of constitutional change. And one certainly might argue, why not have the larger debate, even if it does take a long time? After all, there's no outcry in the streets for urgent reform, no crisis calling out for action, and so on. But nevertheless, on balance, I would say, despite my misgivings and my preference for an alternative route, let us make this change, but with a few alterations. What I would like to see happen is the following: that the bill should be strengthened in some of the ways I've already suggested. Elections should be held in all provinces for all senatorial appointments, should be honored by the Prime Minister, there should be a separate election day, and so on. I realize that such strengthening might well tip this over into a change that does require formal amendment. So perhaps the best way would be to strengthen the bill in the Commons, seek a Supreme Court reference on its constitutionality, see where it does or does not transgress the amendment procedures, and then the court would be able to clarify for the House the scope and limits of what Parliament can do unilaterally, and thus guide the final debate on this bill. Thank you very much, Madam Chair.
Thank you, Mr. Simeon. I can see that all your interventions have provoked many questions. We'll begin with our first 7-minute round. Madame Folco.
Merci, Madame la Présidente. Je voudrais vous remercier, vous trois.
Thank you, Madam Chair. I would like to thank our three witnesses for coming in to speak to us. You are all distinguished in your knowledge of the Constitution, and you are known for your critical spirit regarding the Constitution and regarding the bill we have before us today. I have two major questions for you. The first has to do with the executive's power with respect to the appointment of people who win elections. What I understand from Bill C20, well, nowhere is it said that the Prime Minister is required to appoint the individuals elected in the popular vote. He has the discretion to take the list and to present it to the Governor General. But if I understand the bill correctly, it is left up to his discretion. So he could choose half of the people, he could choose the majority of them, or he could choose none of them at all and decide that the list he would give the Governor General would be people who were not elected through popular vote. So that is my first question. Why in this bill, which goes into such a lot of detail, how should I say this? This is not supposed to have anything to do with the Constitution. It could just go through as regular legislation. Why is it that there were no details given about the responsibility of the Prime Minister with respect to the list? My second question, I hope I'll have time to ask it as well, it has to do with the powers of the provinces. And I believe it was Mr. Hurd who said, and I'm reading the last sentence in English,
Reform without the consent of the provinces. Et pourtant, nous savons que
and yet we know that the representation of senators in their provinces, as it is at the moment, is not the same in all of the provinces of this country. For example, in Quebec, senators actually represent a specific region of Quebec, and that is not true of the other provinces. So how could we change the role, the appointment, and the responsibilities of senators without asking the Quebec government to state its opinion on the subject? Those are my two questions. My question is to whomever would like to answer either or both questions.
Begin answering, or perhaps Mr. Hurd? Either. Mr. Hurd?
She did specifically refer to you.
Okay. There's a number of quite complicated issues mixed up in your questions there, and excuse me if I just focus on a couple of them, perhaps. There's the issue of why the bill doesn't deal specifically with the Prime Minister's role and discretion in recommending nominees. I think the Prime Minister is left out of this bill because the Prime Minister is not mentioned in law with respect to Senate appointments to begin with. So in order to keep this bill arguably constitutional, the less said about the Prime Minister, the better. So I think that's, from a drafting point of view, I would suspect that's why the Prime Minister is not mentioned, why there's no discussion about the Prime Minister's requirement or not to recommend nominees who have been elected. The second set of questions you asked about the role of representation of a senator with respect to their province and how that differs from one province to another. You mentioned the specific and particular role of representation Quebec senators have because they represent one of 24 specific districts within the province. That particularity poses great difficulties for the drafting of this bill on the one hand, and also questions about how this bill has come to be proposed and this change suggested without the agreement of the provincial government, particularly in your interest, the province of Quebec. I've been trying to think how to draft a change to this bill that would accommodate the specific district representation of Quebec senators, and I'm not sure how it can be done. The simplest would be to change the section of the bill that talks about the qualification for being a candidate, and just to say that candidates should be qualified under sections 26 of the British North America, the Constitution Act 1867, and just then say, if you're qualified under that, you're qualified under this. But that doesn't get over the particular problem of districting in Quebec, because one could be qualified to represent one district in Quebec, but that may not be the district that a vacancy can come up with, can appear in. However, it may be a practical solution, because my understanding is that appointments to the Senate from Quebec often involve senators purchasing property in the district they have had no specific tie to beforehand. So it may be sufficient to say that you are qualified under the Section 26 as it is now. You're qualified to represent one district, but if you're appointed to represent another district, then you hurry off and you buy some real estate in that district, so you're qualified. So I think from a technical point of view, an amendment is needed, in fact, to ensure that candidates in these Senate elections are qualified to sit in the Senate. Right now, you can run in this election and not be qualified to sit in the Senate. And in making those changes, we can correct that particular problem for Quebec. The final political issue is that this change is being suggested and proposed without the agreement of the province of Quebec, and in fact the province of Quebec has stated quite clear they are opposed to this bill and Bill C-19 as well. And I think that is wrong constitutionally. I think an agreement was made in 1982. It didn't include the Quebec government at the time, but the rest of the provincial governments agreed that if substantive changes were made to the Senate, they should be done with the agreement of provincial governments. And so this is one reason why I believe that the government is proceeding with the wrong process to achieve what may otherwise be an admirable goal.
Thank you, Mr. Hurd. Do you want to give an opportunity to any of the others?
Well, that's what I was going to ask, if Mr. Watts or Mr. Simeon wish to add to this.
Mr. Watts?
I will only be brief on this. I don't have anything to add on the second question, other than the fact that it does point to one of the reasons why we have the process of constitutional amendment that we do. requiring provincial participation in the process. With regard to the first, I'm assuming that the reason it's not necessary or has not been put into the bill to state whether the Prime Minister has obligations or not is simply the assumption that once you have the electoral process operating, public pressure will force the Prime Minister to follow the expression of public will. In other words, the assumption, I think, in Bill C20 as it's currently worded, for all the criticisms that I've made, is that public pressure will create the convention that a Prime Minister will always have to follow whoever is nominated by the consultative process.
Thank you. Mr. Simeon, I want to give you an opportunity.
Yeah, thank you, ma'am. I agree with that, but I do think still that this leaves a kind of ambiguity in the bill which should be resolved. I would like to take away that discretion from the Prime Minister to make it a cleaner and sharper bill. Although to add one thing to that, of course, if we wrote into the law that that the Senate election result was binding, then you could make, then it would simply be a matter of the Governor General taking note of the result, and there would be no necessary role for the Prime Minister at all.
Thank you. Time's expired. Monsieur Paquette, vous avez la parole.
Merci, Madame la Présidente.
You have the floor, Mr. Paquette. Thank you, Madam Chair. And I'd like to thank our three witnesses. It was extremely interesting. Over the weeks, we've become no, I'm going too far. We're starting to get some idea about constitutional law. And we had an opportunity to hear from Professor Peter Hogg, who appeared before us, and who supported the government's thesis because the government House Leader came in to introduce the bill. He spoke about the optional quality of the Prime Minister's choice with respect to the consultation process regarding senators, which meant that the Constitution was not affected. So I would like to hear from you, and this is addressed to all three of our witnesses. This optional nature or not, is it a determining feature with respect to the Constitution? I would add another question. Hasn't the government tried to do indirectly what it cannot do directly under the Constitution? And I would like you to come back to constitutional conventions in that regard. Substantially, are we not trying to do through the back door what we cannot do through the front door? And in your presentations, you talked about the establishment of an elected Senate without saying so.
To each of you, anyone would like, Mr. Watts?
I'll start off on this anyway. Well, I think your statement is exactly what I've been trying to argue, that Bill C20 is an example of the government trying to do indirectly what it can, or a parliament trying to do indirectly what it can't do directly. And my argument is that if an institution as fundamental as the Senate is going to be altered, we ought to do it directly. I think it needs to be done, but I think that it ought to be done directly. Difficult as that may be, and Richard is quite right in pointing to the difficulties of it, but just because it's difficult doesn't mean we should be devious about it. The difficulties are inserted in the amendment process of the Constitution to ensure a broad consensus in support of amendment. That's why it's important to have the provinces concur. That's why it's important to have widespread public discussion. And one of my concerns is not with the objective of the bill, but with the means. And I don't think the objective justifies the means.
Mr. Hurd?
Professor Hogg and in a Senate committee, Professor Monahan have both argued that the existence of the discretion for the Prime Minister and the Governor General is determinative of the constitutionality of this measure. I disagree. I believe that the court will concern itself more than simply the lack of binding on the discretion of the Governor General. I think it will be concerned with the effects of the process that's set out here, as well as the intent of the process. And once the process is underway and elected senators are included in the chamber by any number, then the powers of the Senate will change dramatically. And there's no doubt that the intention here is to populate the Senate with elected senators. The effects of that would be profound. And I think the Supreme Court would look at the effects of the legislation and not simply the black letter relationship between this process and a process that's detailed in the constitutional documents. You talk about a convention. I think very quickly there would be a convention that only the elected nominees would be appointed, just as I have argued there would be a convention very quickly that the term limits for the House of Commons would become a convention very quickly. This is what the public understand and what the public expect. A law passed by Parliament is thought should be followed. So I think very quickly there would be a convention so that the effects of this legislation would soon be very different from the bare legal framework that it describes. So rather than simply consultative, it becomes determinative.
Je pense que Monsieur Simeon.
I believe Mr. Simeon would like to add something here.
On this point, quite skeptically, they did persuade me in the end that probably this was on the right side of the Constitution at the moment, but they both pointed out that to the extent that this bill becomes more explicit and to the extent it reduces the discretion of the Prime Minister, as indeed I would wish it to do, then we move into a gray area where we get closer and closer, if not actually over the line, into an area where we absolutely do need a constitutional amendment. And that's why I ended up my presentation by suggesting that the committee and the House make this bill a better bill, then before it's finally passed, refer it, as the Senate committee also suggested, refer it to the Supreme Court as a reference, and then the Supreme Court can clarify this issue about which there's considerable debate at the moment, of exactly where Parliament acting alone is able to act to improve the Senate and where it must have provincial consent.
Mr. Simeon, Monsieur Paquet, il vous reste encore du temps.
You have a little time left, Mr. Paquet. Thank you. The possibility was mentioned that the regions of Canada could use the provision that was passed after the referendum in Quebec in '95, which gives the right of a veto right. What do you think about that? Do you think Quebec has come out against the C20? What would be the result of the legislation passed after the '95 referendum regarding the veto right? What would be the impact on this bill?
Regional veto legislation would be followed?
Pas celui qu'on a perdu en 80.
No, not the one we lost in 81 or 82. I think it was Professor Mendez who said that in '95 there was a bill that was passed which gave a veto to the 5 regions of Canada. And he said that the Quebec government could use that veto to block this bill.
Apply for a process that's a formal amendment to the Constitution. And so I don't think in this context the Quebec government can try and seek exercise that veto. What it could do is have a reference question about whether or not there's a convention which requires the provincial consent to a change like this. And we have precedent from the patriation period where the Supreme Court has been quite willing to discuss the content of constitutional conventions relating to federal institutions and constitution.
We'll proceed to Mr. Comartin. Thank you.
Thank you, Madam Chair, and thank you, professors, for being here, and Professor Simeon for being here by remote. Professor Hurd, I'd like to go back to the Constitutional Convention. And Professor Simeon, if you could also comment on this. we don't have a constitutional convention, as I remember my constitutional law, unless there's a process. We actually go through a process. We begin to use the whatever the procedure is, in this case, this consultation process. And so if we, as Professor Simeon's recommending, had a reference to the Supreme Court, there would be no convention for them to consider. Is that correct?
They would not be able to talk about a convention per se, in the sense that the traditional view of convention is you need some precedent as well as discussion and principle. So you need a constitutional principle that is being protected, some statement by the actors that they feel bound by a rule, and some precedent. And that's the formula the Supreme Court looked at in 1980. Right. I think they would carry on and just examine the principle that is involved and any statements from politicians about whether they would feel bound by this in advance. So the Prime Minister, I think, has quite clearly indicated he would follow this process, and that's quite an important statement in terms of setting the foundation for a convention.
But there's no precedent historically in Canadian constitutional law where a constitutional convention has been found before it was actually a practice had been utilized for some time.
There is an example when the prime ministers of Great Britain and the Dominions got together during the imperial conferences, and they came to a number of agreements about how Britain would interact with the Dominions, and they signed some formal agreements about how those processes would play out. One of them was that Dominion ministers would be the ones to advise the King on who would be nominated and appointed as Governor-General in a Dominion. The first precedent came when the Irish did that, but it was quite clear everyone knew that's how it should be done beforehand. And so I have argued in previous work that you may not necessarily already need a precedent for there to be an obligation existing. And those imperial conferences in the 1920s that created a set of conventions where it was clearly understood obligations occurred before the first formal uses of them.
We're going to get into a challenge here, but we were accepting at that point constitutional conventions that were in existence elsewhere within the British Empire.
These radically transformed those conventions, because prior to these agreements, the conventions were the British ministers would advise the King on who to appoint as the Governor-General, and they wouldn't necessarily even consult with the Dominion governments. And so this was quite a radical change and a step towards our independence to say that Dominion ministers would recommend the new Governor-Generals to the King.
Simeon, I see you're writing. Would you like to add?
Yes, I'd like to come in on this if I could, Madam. First of all, I think we should note that how a convention solidifies into constitutional law is one of the great mysteries of constitutional law. And I think there are different ways in which they can come about. The most obvious way to which has already been referred is through history and precedent. That's the way it's been done and been done over again, and it takes on a certain legitimacy and a certain expectation of all political actors. That's what the Supreme Court relied on in the Patriation reference, saying black letter law, yes, Ottawa, you can do it. Convention, no. You have to have substantial provincial consent. But the Supreme Court also displayed a second basis for developing convention in the Quebec secession reference. That was based not on history and precedent, but on what the Supreme Court said are the fundamental values underpinning Canadian federalism. That's what made it a constitutional convention that Ottawa would have to negotiate with Quebec. And then thirdly, there can be a catalytic event, which I think very quickly can establish a convention. And arguably, the Charlottetown reference is such an example. Some people, and I think I would be one of them, would argue that even though we've only done that once, we will never again make a major substantial constitutional change without popular consent. So many ways to skin the conventional cat.
Thank you, Mr. Simeon. Mr. Watts, would you like to enter into the fray here?
I'll stand with what my colleagues have said.
Thank you very much. Mr. Comartin, you still have some time.
Yeah. To pursue this, if there isn't a reference, I guess I'm asking all three of you, do any of you believe that there won't be a court challenge either from the province of Quebec or one of the other provinces, or perhaps from one of the political parties?
A start, I would certainly be surprised if there were not.
Professor Hurd?
I agree.
Yeah. And I expect there would be too. Yeah.
So going back to Professor Simeon's recommendation, the reference should flow out immediately from the government rather than to the Supreme Court rather than wait for the litigation to come from somewhere else?
I think that would be the wiser course of action, although one might consider what Richard Simeon has suggested in terms of looking first at what modifications you might make to the bill before it's referred. But ultimately, I think it would be wiser to refer it first rather than waiting to be challenged.
Thank you. Mr. Simeon, do you have any
I absolutely agree with that.
Yeah. Thank you. Well, you're still under time. You have 1 minute.
I'll pass for now. Thank you, Madam Chair.
Thank you. Mr. Reid?
Thank you, Madam Chair. Pursuing the discussion of conventions a little further, my understanding of a convention, and I am prepared to be corrected if I've understood them incorrectly, is that fundamentally what distinguishes a convention from any other principle is that it is enforceable by public opinion. If public opinion is willing to tolerate a divergence from what had appeared to be a convention, then in fact it wasn't actually a convention. If public opinion is not willing to accept that, and don't mean public opinion in the sense of public opinion polls, I mean public opinion as expressed at a more fundamental level, for example at the next election, then it suggests that the convention either exists or doesn't exist based on that. Do you understand convention differently than that, or do you understand it the same way I do?
I think there's quite a complex role that public opinion plays in conventions. I wouldn't agree with a blanket statement to that extent. I think the public opinion is sometimes very difficult to know on a specific event, and particularly in reference to an election, whether an election either casts doubt on a past government's actions or legitimates it. One of the problems we have with our electoral process is we have no idea. It was very difficult to know if there's a majority support for a particular action or a majority against a particular action, because governments are elected to a majority position without a majority vote. So it's very difficult to interpret raw election statistics as to whether or not they support what has or has not happened. The other thing about conventions is that I would say there are times when governments get away with something, and that in hindsight and over time it's quite clear that a convention was broken, whether or not there was a public outcry at the time. The consensus afterwards was the government should not have done something, or the government should have done something. So public opinion at a particular time is informative for us to try and determine whether a convention exists, but it's not determinative in and of itself.
I'm glad, actually, Professor Hurd, I'd actually made the question in a general sense to all the witnesses, but I'm glad you answered it, because I wanted to ask you the following question. Now, I wasn't sure if you were suggesting that the creation of a convention, or a law which will likely have the effect of creating a convention, is a basis on which one would judge the constitutionality or unconstitutionality of the law. That is, if it aims to create a convention or has the practical effect of creating a convention, that in and of itself would be a basis for saying that it is unconstitutional where the law might otherwise not be unconstitutional.
The courts have at times used conventions to understand the effects of a legislation or understand unwritten aspects of legislation. So they have at times used convention to enforce the relationship between the cabinet and the House of Commons, and so that you can deal with someone as a cabinet minister through legislation that deals with them as a member of the House of Commons because of the Convention of Responsible Government. So they have at times used convention to understand and make judgments about the constitutionality of legislation. There are limits to what they do with that, definitely. What they are concerned with is the effects of legislation to a significant extent, and where conventions can help understand the effects of the legislation, then they will bring them into consideration.
I hope you understand why I'm asking this question. It's because the argument has been in the air. I don't know if anybody's formulated it overtly, but that the degree to which these elections are binding or become de facto binding seems to be viewed by some of the people who have appeared here as witnesses and in some of the questions as being a consideration as to whether or not the law winds up becoming unconstitutional, despite the fact that nobody would make the argument that the royal prerogative in the purest black letter sense is being violated. Clearly, on paper at least, the Crown retains its absolute discretion, and in much the same way that the Crown retains the discretion it has failed to exercise for 300 years to refuse to sign laws into effect after both houses of Parliament have in fact passed them. I'm just trying to get clarity on that point, simply because that could affect how one were to deal with the legislation, how one were to try to amend it in order to make it constitutional, etc. I guess I've made that more as a comment than a question, but I suppose that would probably invite some comment from you, so I might invite that.
Mr. Watts?
Well, I'm inclined in a situation like this to almost come with a counter question. That is, if one judges from the preamble of the bill that the essential thing, the essential objective is to democratize the process, why do we defend it by arguing that the democratic aspects can be ignored? We're talking out of two sides of our mouths here. We say that the whole idea is to democratize the process, but we defend its constitutionality by saying, but of course we don't have to be democratic in the way we use it. I just don't understand that double talk.
Well, I suppose the answer to that is that there is a very strong will, popular will, to have a more democratic Senate, and there is a constitutional injunction against having a fully democratic Senate. That would be the answer to your question, Professor Watts.
Well, so B will then change the Constitution. You know, the Constitution is not sacrosanct. Yes, we've had problems in the last 3-4 decades in changing the Constitution, but in a discrete, particular area like this, I think that a Constitution is not immutable. It's meant to be adjusted to fit the developments of the country. And I would argue that that's where the change should be made.
I appreciate that, and I just want to make the point here that you have switched from arguing making a constitutional argument to making a political argument. That is, that it is desirable to change the Constitution. We ought not to regard it as sacrosanct. We ought to be willing to open it up. These are all political arguments. They are not, as far as I can tell, constitutional arguments. And I do think, for the purpose of trying to go through the exercise that this committee has to go through, it will be important for us to distinguish between the political argument as to whether this legislation is desirable and the constitutional argument as to whether this bill is constitutionally permissible.
I would say by all means make the distinction, but the constitutionality is not the only issue here. It's the desirability that is expressed in the preamble. It's a political bill. It's not just a constitutional bill.
I'm going to neglect Mr. Simeon. Would you like to add to this
Can I
debate?
just add something to that? I agree completely with my colleagues that very quickly, once this bill were passed, it would become politically very, very difficult for the Prime Minister not to accept the result of election. But I think at the beginning, the sanction for that would be political. It would be a convention in the sense that it was expected by most political actors, and the Prime Minister would pay a price if he didn't do it. But I think it would take a certain amount of time And for that to happen repeatedly before the Supreme Court would use convention in the harder sense, that it has solidified into a judicially enforceable convention, has become part of our Constitution. And my guess is that the Supreme Court, would take a while before they said that it's become a convention in that second sense.
Thank you. Mr. Savage, the next round is 5 minutes.
Thank you very much, Madam Chair, and thank you to the speakers. This is not my normal committee, but I'm very interested to be here, and I appreciate the fact that you've brought your learnings to us. As a bit of a student of history, I was interested to learn, Mr. Watts, about John A. Macdonald and the fact that in 1864 he had learned that, or had come to the belief that, in fact, elected senators weren't a good idea, and that an appointed body chamber would, in fact, be better. Coming from Atlantic Canada, as I do, Nova Scotia, the Senate's been has played an important role for Atlantic Canada. As members know, that when Confederation happened, there was 24 members from Upper Canada, 24 members from Lower Canada, 24 members from the two provinces in Maritime Canada, which entered Confederation then. I think that when Prince Edward Island joined in 1873 or in the 1870s, that they fit into that 24 from the Maritime. So that regional component has been important to Maritime Canada. And looking at it in Nova Scotia, it's not quite like Quebec in that you have distinct 24 regions, but we've always had, for example, an Acadian senator from Nova Scotia. We've had African-Canadian, African-Nova Scotian senators before we had African-Nova Scotian members of Parliament. We had some very great champions in a whole areas of society in Nova Scotia, cultural society. We had Sister Peggy Butts, who was appointed by Prime Minister Chrétien in the 1990s, who was a poverty advocate, and they've all, in my view, brought some great honor to the Senate and to the parliamentary process in Canada. There are a number of people who have expressed to me a concern about the Senate. Is it worthwhile? I must say that having been here for a few years now, I've seen the work you referred to Senator Siegel, to Senator Macdonald, to the work that Senator Kirby did in a couple of major commissions. And, there's a lot of good work that's done in the Senate. I introduced today into the House a private member's bill from the Senate, which has passed the Senate, come to the House of Commons. I must tell Canadians there is, in fact, quite a bit of work done by the Senate. I would say that, even as a Nova Scotian, and the fact that we have more senators than British Columbia or Alberta doesn't make sense to me, and that we need to make some changes in the Senate. I think anybody would accept the fact that we need to make changes. Each of the four founding provinces of Canada, if I can use that term, the original four, Quebec, Ontario, Nova Scotia, New Brunswick, have objected to this legislation, and we've talked a lot about the process here. My only question to you is simply, would there not be a better way? Would this not have been something better started? You've referred to it as a political bill, and in essence everything that comes to the House of Commons is political, but this certainly seems to be more politically based than policy based. And is it not a better method of consultation, perhaps a First Ministers' Conference to start the ball rolling to decide on what kind of reform should be done with the Senate? I'll ask anybody who wants to answer on that.
Well, I'll fire off to start with, but let my colleagues go on. Just briefly, I guess that's the heart of my plea about the second point that I was making in saying that my concern about this bill is that it deals with one aspect without dealing with the interrelated and equally important aspects that affect the contribution that the Senate can make to Parliament and to the Federation as a federal institution. And that therefore it seems to me that I would prefer, all fears of the problems of constitutional amendment aside, that I think we do need to look at it fundamentally in terms of the role it plays within Parliament and the Federation.
Thank you. Mr. Hurd.
I think the issue of distribution of seats is very much tied up into the powers of the Senate and how the Senate uses those powers. And this is why In 1982, it was agreed that any changes to the method of appointing senators or the powers of the Senate should be dealt with through the general amending formula. The effect of having elected senators would alter the behavior of senators in a number of ways. Some we can tell ahead, some we won't, but it's more likely than not that they will feel more emboldened. And so the level of interaction and amount of legislation they amend and the position they take on bills that come from the House of Commons will probably be more strident than it is now. Having more powers and more of an influence in the policy process, other provinces across the board will be concerned about their representation and how many hands on that power they have. And this is why I feel, from a constitutional point of view, the Supreme Court would be sensitive to this issue, and a bill that might have an effect on the powers of the Senate would be something they would say should be protected under the amending formula, or is protected under the amending formula.
Okay.
Thank you. Mr. Simeon?
Just a couple of things about that. First of all, as I said at the opening, I think that the process that's being followed here is very much a second best, and I would very much prefer a proper constitutional process. I don't think it's purely political. I think there is a genuine fear that opening the constitutional Pandora's box would just lead us into endless debate and frustration and so on. And I pay some attention to that. And that's why I think we should explore what the Parliament can do in this regard. But the other thing I just want to say is, about what, as I said, we don't know exactly what an elected Senate would be like and how it would behave and how partisan it would be and so on and so forth. And I know that many people would say, oh, this is turning the Canadian Parliament into something much more like the American Congress with two powerful legislatures and so on and so forth. First of all, as I say, we're not sure about that. And secondly, we're not sure, or I'm not sure, that that would be such a bad thing. We have now the tyranny of party discipline. We have the tyranny of one-party government. We have the tyranny of simple majority rule in the House of Commons. Is that so great? Maybe more and more powerful voices and so on coming at the issues from a somewhat different perspective would not be the end of parliamentary government as we know it, but something better. I'm not predicting that, but I'm saying we shouldn't just hold on to the existing parliamentary system we have as if it's a perfect working model.
Thank you. Mr. Hill?
Thank you, Madam Chair. I just want to perhaps pick up on where Mr. Simeon left off a couple of seconds ago. One of the things that really frustrates me, maybe being a bit more being a Westerner, has been this whole defense of the status quo by, in particular, by the Liberal Party of Canada over my lifetime, political lifetime. I've been here almost 15 years now. By both Prime Minister Chrétien and Martin, where every suggestion that was made to make any change to the status quo situation of the Senate of Canada was met by, we're not going to do anything piecemeal. That was their standard response in question period, in interviews, every time they were asked during debate during election campaigns, was they weren't going to do anything piecemeal. In other words, it kind of fit in with what Mr. Watts is suggesting, which is that, if we want to bring about meaningful Senate reform, that the only way to do it is to open up the Constitution and sort of do it, quote, quote, properly. I can tell you that this is very frustrating for vast numbers of Canadians, I believe, that want to see our institutions evolve somewhat. And I think that what we have to deal with sometimes is what is within the realm of the possible. And I think that's what Bill C20 is dealing with, is what is possible. I don't have in front of me today the full list of how many times over the last
100-plus years, successive governments and parliaments and scholars have tried to initiate some substantive constitutional change to the Senate. But I think all of us would agree, anybody that's taken even a superficial look at it would agree that it's been an extraordinarily frustrating exercise to go through. And that's just even with the people that are still alive that have gone through that, whether it was the Charlottetown Accord that led to the referendum, or before that the Meech Lake Accord, which are the two in recent memory. And my understanding, and this is where I would look for some direction from the three gentlemen, is that even the United States, how their elected Senate evolved was piecemeal, if I can call it that. That's my understanding, at least, is that the individual states began to elect their senators. And it happened over a period of time. And it gradually, as Mr. Simeon was trying to indicate, I believe, it gradually evolved that became the norm as opposed to appointment. And eventually it created enough of a groundswell from the public that was the accepted standard that they ended up with a fully elected Senate south of the border. And I would ask the learned gentleman, I guess, if they could point to other examples where that's indeed how Senate reform in other democracies came about, where it was, in effect, piecemeal, I guess. I mean, it started slowly and grew as public pressure said, well, you know, maybe there is a better way to do this.
Mr. Watts.
I guess that's directed to me because I was the one who was arguing about the importance of taking other aspects into account. I worry about taking the contrast between piecemeal, as if very small on the one hand, and opening up the whole Constitution on the other. I'm not arguing that we open up the whole Constitution. I'm saying we open up the issue of the Senate. It's an important part of the Constitution. But I think the danger, if one looks just partially at one aspect, is that one gets into a situation where that aspect interacting with the existing powers of the Senate. If you look at the Constitution amongst parliamentary federations, leaving aside those like the United States, Mexico, Brazil, Argentina, which have congressional presidential systems, leaving those aside, if you look at parliamentary systems, we have, on paper, the most powerful Senate in the world amongst constitutional federations. We get away with it because by convention that Senate is unwilling to defy the House of Commons where the House of Commons clearly has popular support. When you change that so that the Senate is based on an electoral basis without changing its powers, then you can get into a very risky and dangerous situation. That's my concern about looking only piecemeal at one little bit. When you ask about the American process, you're partly right. Yes, that's the way it happens, state by state. But in the end, it was a formal constitutional amendment that applied it everywhere in the United States. So it was a formal constitutional amendment in 1913 that made elections to the Senate by direct election rather than by state legislatures. When one looks at piecemeal processes, there are some successful, there's some unsuccessful ones too. Malaysia is an example. Malaysia started with something like 3/4, 2/3 of its senators indirectly elected by the legislatures and a small portion appointed. By a process of convention, they have come to the situation now where 3/4 of their senators are appointed. That's not a very desirable progress, bit by bit, piecemeal, which is what has occurred there. That points to the dangers of piecemeal approach to a reform when it interrelates with other aspects. I don't want to open up the whole Constitution. I've got lots of scars to bear from those efforts of the last 40 years. And I recognize fully the frustration and danger of those. But the fear of that is leading us into the danger of going to the other extreme, of trying to do such piecemeal reform that we don't take account of how it interrelates with what is actually already in the Constitution. And that's my concern.
Would either of the other two like to make a comment?
Just
Mr.
add
Hurd?
a brief comment, and I understand and share the frustration that you express coming from British Columbia. I hear a lot of concern about Senate reform there. The one thing, though, that I caution is that there are certain things that one can achieve through political practice and convention, and certain things one can achieve through ordinary legislation. And what one can do through legislation has its limits. What one can do through convention has its limits. Certain things can only be done through constitutional amendment. But an informal change could quite easily be undertaken by a government saying, we're going to act on a list of nominees from provincial governments. We're going to break the patronage mill that we've had up till now. There's nothing to stop the Prime Minister now saying, I'm going to appoint with consultations with the premiers from now on. That would be an important change to the Senate and an important change to federal-provincial relations. But if one were to bring in legislation to say that, one might run into difficulties. And this is one of the ironies of constitutional innovation. There's some things you can do informally that you cannot do once you try and write it down in law. And one of the concerns I have is the particular process that is chosen now may have problems from a legal point of view. But that's not to say there are other things you might do legally as opposed to this particular process.
Mr. Simeon, would you like to enter into the discussion?
Yeah, I find this discussion is going in an interesting way because we're talking about two kinds of fear here. First of all is the fear that's just been expressed, and was expressed by Ron as well, of the potential difficulties of two houses with formally equal powers now, both of them being elected rather than only one of them, and the possibilities of danger and being risky and so on and so forth. I mean, that's certainly true. Although I think it should be noted that the transition to that period where it was a fully elected Senate as well as a fully elected House would take quite a while, and we'd have a long time to see how it began to develop. But on the one hand, there's that fear, which says don't pass this bill. And then there's the fear of opening the Pandora's box of constitutional amendment. And the worry that if we do that, then we get into another endless debate. There's the fear that we couldn't keep it focused just on the Senate, that as we saw in Charlottetown, the agenda would just get bigger and bigger and bigger and bigger and so on. So given those two sets of fears and the desire not to just to be bogged down in the status quo, it seems to me that it's desirable for all of our political institutions to explore as much as possible the freedom of action or the range of things that they can constitutionally do. And that, again, is the reason why I wanted to propose that, yes, let Parliament use its imagination, test the limits of what its constitutional powers are, but not through force majeure, but then consult the court to see if it is still within the bounds. If so, great. If not, the court will tell Parliament that, and Parliament will have to draw in its horns and so on. And I would say the same thing about the provinces, in the sense that I know the provinces don't have any rights at all in the appointment of senators. I've often thought that they should. But there's absolutely nothing, as we know, to prevent provinces having elections in order to generate a name that they want politically to put in front of the federal government and the Prime Minister. And I said, that seems perfectly fine to me. It's testing the limits. It may or may not work. But it's another kind of example at the provincial level of trying to open up a process which we've all agreed is a kind of not very effective one.
Monsieur Lévesque, vous avez la parole.
Mr. Lévesque. Thank you, Madam Chair. I would like to thank our witnesses for sharing their expertise with us, and thank you for traveling here to do that, and thank you for being available to us, Mr. Simeon. I think that Parliament itself should sit in on some of your classes to get a good idea of what we're talking about. Regarding this bill. For example, there's the House of Commons as opposed to the upper house and the Senate. I think it was called the upper house because I believe that in the thinking of the conventions and in the legislation, well, I'm not sure. I'd like to hear your views on it. Would the Supreme Court not be tempted to see what the conventions have in mind when it makes a decision as regards the legitimacy of such a bill, particularly if C20 is compared to C19, which is also before Parliament? If the two are read together, is there not an automatic obligation to reopen the Constitution because there is a major amendment involved? And as far as I know, the negotiations with the provinces have not happened. So that would mean that an upper chamber would have almost equal power as those of the House, and senators would be subject to the pressure of civil society, the same pressure that is felt by members of Parliament at the moment. And the quality of the decision-making by the Senate would be questionable. Mr. Simeon was talking about that, and Mr. Hurd as well. And I would like to hear what you have to say about that.
I believe the Supreme Court would pay close attention to the conventions and how they affect this bill. This relates to some of the questions from Mr. Reid and Mr. Comartin earlier. I think one of the issues is, would the court simply deal with the black letter of the law, or will it expand it to public expectations and to constitutional conventions? And my belief is that the Supreme Court would treat this as one of those areas of law where it cannot simply take the black letter of the law. It must look at the context and the effects of it. And it would, therefore, look at the public expectations and whatever conventions would or would not operate around that area of law. And I mentioned earlier the Quebec secession reference, where in terms of the black letter of the law, the Supreme Court could have and perhaps should have just said Quebec does not have a right to separate in international and domestic law, period. But they went on to say something else. And I think the same thing would apply here, that there are some areas of law where you cannot simply stop with the black letter of the law, and the Supreme Court would talk about the expectations of the public and what conventions would occur. Would relate. In some respects, in the Quebec secession reference, the court created a brand new convention. Everyone now believes the federal government has an obligation to negotiate separation if a clear majority vote in favor of it. I would say that's now one of our conventions of the Constitution. We don't need a referendum to come along and tell us that that is in fact a constitutional obligation on the government. And this was something authored by the Supreme Court of Canada, quite curiously. And my belief is that the Supreme Court would take this area of law with respect to the Senate and would look at it in the same kind of political context and make some very strong statements about the obligations of the federal government and their relations to provincial governments in dealing with the central institution of this federation.
Thank you. Mr. Simeon?
I think one thing that we're perhaps avoiding here a little bit, and it might be an issue where the Supreme Court to really explore this in the kind of detail that Professor Hurd just mentioned, and that is the wrong that we're trying to right here, which is a completely undemocratic Senate appointed by prime ministerial power, which is essentially unlimited, which, as Ron West pointed out, is utterly unable to perform the balancing and regional representation that senates are designed in most federations to perform, and so on. So we have a failed institution here, one which is, if one had to sort of say what's wrong with Canadian federalism, we would say it was this aspect of it that was wrong, this inability of the central government fully to represent all Canadians, fully to be an arena in which the interests of regions and the national majority would be negotiated and accommodated. So that would be part of the discussion as well. The Supreme Court has said, as it did in the secession reference, that federalism is a fundamental Canadian constitutional value. We have an anti-federal Senate. Says that democracy is a fundamental Canadian value. We have an undemocratic Senate. So it seems to me that this is why I just want to explore all the different possibilities, that we want to move off an institution which is a blot on the Canadian political system at the moment.
Thank you, Mr. Simeon. We'll now turn to Mr. Preston.
Thank you very much. Again, I thank you all for being here, and I'm learning as I go. So this is great. It's not my regular committee either, but I'm really charged with what I'm hearing. I guess I want to start with some of the things that have already been said. I continue to hear, and I won't necessarily point, that it's an admirable goal. What we're trying to do is at least a step forward. But that I think Mr. Simeon, you said the process is second best. But then you said, let's explore what the Parliament of Canada can do. I guess I'll ask you the question then. If this is second best, but you want us to explore what the Parliament can do, what are you suggesting?
Shall I try to answer that?
Sure.
Yeah. Okay. Well, I think in my initial presentation, I think I did make a suggestion. The suggestion would be to try to fix some of the weaknesses in the current bill. And I think most of the weaknesses have to do with the fact that it's not clear whether this is or is not finally an elected Senate, because the Prime Minister retains the discretion. We don't know how he'll use it, but nevertheless retains the discretion to decide whether or not there will be a Senate election, whether to accept the result, whether it'll be in some provinces but not in other provinces. That seems to me to be far too much uncertainty in the bill. And the other big recommendation I made was that the election not be held coincident with a federal election or a provincial election, but on a separate day. So I think what the committee, what I would like the committee to do is to strengthen the bill, tighten it, clarify it, right? So it becomes more clearly an elected Senate bill. But then we understand that that gets close and maybe over the line to doing something which Parliament does not have the constitutional authority to do. There is not a consensus on that question. Lawyers like Peter Hogg and Pat Monahan and André Gélinas have said it's okay. This bill is okay. But even they worry that once you add Bill C-19 to it and tighten it up, then it might cross the line. So what I would like to see the committee do is craft the best bill they can, then submit it to a Supreme Court reference. And that will test the waters, test whether and how the federal Parliament on its own can try to improve the Senate. The Supreme Court says, no, you've crossed the line, then we have to go the constitutional route.
Well, Mr. Simeon, I agree with your first part, that this committee should try and craft the best piece of legislation it can, but we have talked here also today that public consultation, or at least public opinion, needs to be gathered on the subject, whether it's a full constitutional review and so I just personally disagree with getting as far as we can or the best we can and then narrowing the consultation to it just being the Supreme Court. I'm not certain that's public consultation. I'm not certain that's bringing the public into it. I think that's narrowing it after the best work we could possibly do. I'd like some comment on that. I really am not. It doesn't have to be just you, Mr. Simeon. Please go ahead.
Everybody up to the challenge? Mr. Simeon, would you like to?
I just have to say I really accept the power of that comment, and I guess the question is whether one tries to move ahead with what's on the table right now or step way back, because I do believe, yes, that in the whole question of improving democracy in Canada, we just need much more public deliberation. And even though their proposals did not get accepted, I thought the citizens' assemblies in BC and Alberta were a model that actually might work in an area just like this. So I accept the contradiction in my own thinking here.
Thank you, Mr. Watts.
Well, this is why I argued earlier on that Senate reform is urgent and important, and that that's why we may have to go through a constitutional amendment procedure for the Senate, because that procedure involves wide consultation. I mean, that's the whole point of the requirement, of the requirements in the constitutional amendment process, that when you're dealing with something that is a fundamental value in our political system, it requires that breadth of consultation and involvement. And I'm not a defender of the status quo for the reasons that Richard has already said. As a comparative scholar of federal systems, I've come to the conclusion that there are many things in which there are lessons we can teach other federations. But one area where in comparative terms we are weakest is in the form of our federal second chamber. Not that it hasn't done some good things, but in terms of its function in creating a cohesive federal system, it is not performing that function. And that's not the fault of the individual senators, it's the form of the structure that was set up. And so that's what we have to deal with. But that's why I think this is fundamental, important, and urgent.
Mr. Preston, I see you're eager. I'll allow one short, very short question.
Well, I guess I want to follow up to what Mr. Watts just said. We keep talking about can we open the Constitution on just Senate reform? Do the three learned gentlemen believe that we can do that? I for one don't believe it can be opened on just one piece of Senate reform, for example. I'm not sure if we keep hearing we open the box, what else jumps out? So I ask for you to.
If I can reply to that one, if you look at the experience of most other federations, they have many discrete constitutional amendments. We've even had some on things like education in Newfoundland.
Bells. Excuse me. Hearing the bells, I'm informed that I have to suspend immediately unless there's unanimous consent to continue. And actually, since we're just next door, I mean, we could continue for another 5 minutes or so. Please.
Until one of us is over there anyway.
Okay. Good point. We have our whip here, so Mr. Watts, please continue.
I've lost where I was now, but
sorry.
But I think, as I say, I think it's urgent, and I'm not a defender of the status quo, and for reasons drawn from the comparative study of federal systems, I think we need to do it.
I heard Mr. Simeon as to whether they agree with your ability to do discrete opening.
I'm skeptical about the ability to have a discrete amendment. It can happen. I would be delighted to be surprised. But I think there are probably bigger priorities in terms of democratic reform that relate to this House rather than the upper house.
Madame Falco, you have the last round. Oh, sorry, Mr. Simeon? Do you have a comment?
I just agree with what my colleague just said.
Thank you. Madame Falco? Oh, I'm sorry. Mr. Simeon, would you like to clarify what comment you agreed with?
Well, that it's urgent, that the weakness of our Senate is the largest single weakness in our federal system. And much as I would like to be able to focus a big public deliberation on the Senate and keep it limited to that, I'm just afraid that given the way our constitutional politics is developed, that would be really, really hard to do, much as I would like to.
Thank you, Mr. Simeon. Madame Foucault, you have the last word.
Merci, Madame la Présidente. Et ma question sera...
Thank you, Madam Chair. My question will be brief because what we've been talking about so far are fundamental issues. And I have a question that's more of a detail. As far as the election process would work for the election of senators, a number of individuals would be authorized to put their names forward for the Senate for a particular province. Let's say that there would be 3 vacancies, so there were 3 people. So we would say to a certain number of individuals, you can put your name forward for the same Senate. There are 3 vacancies. The problem is this. According to the system that we have in place for the House of Commons at the moment, when a person runs in an urban riding, the population is very dense. So a person can be elected in a small area where the population density is high. If you go to an urban region, the opposite happens. It's a large area with a low population density. I've asked this question of other witnesses. If I were to run for the Senate, say, I would prefer to run in Montreal. It would be easier for me if I were from Montreal because I know many people there, many people know me and might vote for me. So I'd prefer to do that rather than to run in Val d'Or, where it's difficult to do your campaigning because people are so far apart. I think there is a systemic injustice here as to how we would vote, how the various names would be put forward. Would you care to comment on that?
In the particular context of Quebec elections,
excuse me, wasn't thinking Quebec particularly.
Right.
I just took the example because that's where I'm from.
Yeah.
But it could be British Columbia.
I don't know how one can avoid that problem in terms of who one is to represent as a senator and how one gets elected. I don't see an answer to, an improvement over province-wide elections, as difficult as they are. I think they help create a larger focus in the Senate. I think we are meant to have community representation in the House of Commons and broader provincial interests represented in the Senate. So my own personal belief is that we should keep elections province-wide to the extent possible for senators.
If we could have quick comments from...
Point of clarification,
yes.
Madam Chair. Thank you. It was my understanding that unanimous consent was given to hear the answer from the previous question, not unanimous consent to start another round and stay beyond
Are you
votes.
objecting then? Then we will suspend.
I don't want to miss the vote.
Okay, well, I think, okay. Then I'd like to thank our witnesses for a combined century of wisdom and insight into our deliberations. Thank you, and that will, the meeting is adjourned.